Hello, bankers. A very good evening to all of you. Welcome back. So, welcome to GIV CIV Prep. So, guys, in this particular session, we are going to continue with our discussion based on unit asset classification and provisioning norms, right? So, in our previous session, we have covered the maximum portion of this particular one, especially these two subtopics. So now there are some areas like IBC 2016, NARCL and PCA. There are some additional content which is given in your book itself. So that we are going to practice with the help of a number of MCQs in this particular session itself, right? So our last question which we discussed in our previous session was around moratorium. ठीक है? So which of the following statement is correct regarding the classification of NPA for industrial project and agriculture plantation where a moratorium is provided for interest payment? ठीक है? And the right answer was interest does not become overdue during that moratorium period. ठीक है? So, but only after due date for the payments post moratorium. Let's say the moratorium period is for 90 days. So, during that 90 days, we will not classify that particular asset as non-performing asset again. So, if it remain overdue after that particular one, then only it will be categorized as non-performing asset, right? So, in the case of bank finance given for industrial project and agriculture plantations, where moratorium period is available for a payment of interest become due only after the moratorium or gestation period is over. So such amount of interest do not become overdue and hence do not become NPA. With reference to the date of debt of interest, okay, they become overdue after the due date for payment of interest if the interest remain uncollected, right? So this was our last discussion in our part one. So now the other part or the other important subtopic of this particular unit that we are going to discuss again with the help of MCQs and application based questions. So which of the following correctly describe the shift in the Indian insolvency regime introduced by Insolvency and Bankruptcy Code 2016 IBC. Okay? So IBC which generally introduced so earlier there was debtor in position and we generally shift this particular one to creditor in control, right? So debtor in position means after becoming default itself, जैसे कोई कंपनी आपका डिफॉल्ट करती है, so the management आपका we are generally running that particular company with the old management itself. ठीक है, जैसे we have a case of Kingfisher Airlines. ठीक है, तो जैसे आपका Kingfisher Airlines के द्वारा डिफॉल्ट किया गया, तो सेम मैनेजमेंट आफ्टर इवन पोस्ट डिफॉल्ट ऑल्सो, ठीक है, और इवन द ड्यूरिंग द इंसॉल्वेंसी डील्स एंड ऑल, ठीक है. So the old management was handling all the cases and all. Okay? But we with the IBC 2016 we changed this particular one to आपका creditor in control. Okay? If a company become insolvent, okay? So now the creditor will appoint the management to run that particular company as we experience in Jet Airways and others. ठीक है? तो ये जो आपका change था, this was a very big change during that particular period. And even if a director of a company let's say there is a person A who is director of a company or who is a director of 2-3 companies. So if any company make any default, so he will not be liable to raise funds for the another company and all. So there are some certain guidelines around that particular one. So it shift creditor in control model to no, it should be reverse. Debtor in position to creditor in control. So this make this wrong. It maintained in the traditional debtor in position model, but introduced a faster resolution timeline. No, it shifted from debtor in position model to creditor in control model, allowing creditor to appoint a new management. 100% true. So option C will be right answer for this one. Okay. So before IBC, distressed companies retain control over their management even after insolvency proceedings begin. So it was debtor in position model. IBC introduced a creditor in model allowing creditors to take charge and appoint new management to revive the company. This shift made aimed to prevent misuse of insolvency proceedings by defaulting promoters and ensure quick resolutions. Okay, so this was one of the biggest changes during those particular one. Okay, let's have a quick look around the summary also. Okay. So Insolvency and Bankruptcy Code 2016. So IBC 2016 enacted on May 28, 2016 against the backdrop of mounting non-performing loans with a view to establishing a consolidated framework for insolvency resolution of corporations, partnership firm and individuals in a time-bound manner seek to tackle the non-performing assets (NPAs). As cited above, Government of India has enacted IBC, which is the most comprehensive law, and in the process has consolidated the existing laws and rule through a single legislature to help bank to enforce insolvency and bankruptcy proceedings. Under IPC, Indian insolvency regime shifted from debtor in position to creditor in position. So this was the bigger change. The creditor in control model hand control of debtors to its creditors and relies upon the managerial skill of newly appointed management to take over an aligning company and ensuring business continuation. The Supreme Court in Swiss Ribbon and Union of India has held that the core objective of IBC is to ensure revival and continuation of the corporate debtors. Thus, the IBC has a larger public welfare consideration in play. Okay, so this was a kind of core things of this change or the very important part from this particular one. Okay. So now next question, guys. So the Supreme Court in the case of Swiss Ribbon and Union of India emphasizes which of the following as a core objective of Insolvency and Bankruptcy Code 2016. Okay. So what was this? Revival and continuation of corporate debtors. Okay. So liquidation defaulting companies, no. Option B, revival and continuation of corporate debtors while ensuring public welfare consideration. 100% true. Okay. So option B only will be right answer for this particular one. So that we discussed in our previous slide also. So Supreme Court in Swiss Ribbon and Union of India held that revival rather than liquidation in the primary objective of IBC. The code was designated to help distressed companies recover, ensuring business continuity and minimizing job losses. This enforced the public welfare approach of IBC rather than treating it solely as a debt recovery mechanism, right? So this is very important one again. Please do remember these things. Next one. According to IBC 2016, which of the following entities can trigger corporate insolvency resolution process? Okay, so which entity they can trigger or they can file cases under IPC? Okay, so it can be IBC, sorry. Okay, it can be financial creditors, yes. आपका like bank and other institutions. Operational creditors, those who have like these are the vendors and all and employees even. And corporate debtors. So corporate debtor itself, they can also file the आपका IBC. So option D will be right answer for this one. So IBC provide that CIRP can be initiated by three categories of the person: financial creditors, bank and bondholders; operational creditors, suppliers, vendors; corporate debtors, the company itself. Okay. So this ensures that multiple stakeholders can initiate insolvency proceedings, making the resolution process more inclusive. Next one, guys. What is the primary purpose of moratorium imposed once an insolvency petition is admitted under the IBC? The primary purpose of moratorium imposed once an insolvency petition is admitted under the IBC, to provide complete immunity to a key managerial person of corporate debtors, no. To prohibit all proceedings against corporate debtors, including those against the guarantors, yes, it can be. To prevent further depreciation of the corporate debtors asset while allowing proceedings against to prohibit all proceedings against, to prevent further depletion. So option C should be right answer for this one. Okay. To prevent further depletion of corporate debtors, assets while allowing proceedings against key managerial persons like directors in all team to protect the interest of an option C, yes, हाँ, ठीक है. So as held in P. Mohan Raj versus Saha brother Spat, moratorium prohibit legal action against the corporate debtors during CIRP. ठीक है. Then uh, the purpose of the purpose is to act as a shield to prevent further depletion of assets. However, it does not protect key managerial persons responsible for the insolvency from legal proceedings. So guarantors and responsible individual can still face legal action despite the moratorium also. So this is the one. Next one. Under the Insolvency and Bankruptcy Code, which of the following received the highest priority in the liquidation process? Okay, so highest. If a company is going through the insolvency process and if we are going for some sort of liquidation, so which of the, like out of these four, which will get repaid very first? तो क्या होगा आपका सबसे इसमें employee salary, right? So workers salary for up to 24 months. ठीक है, first. Then second will be आपका shareholders. ठीक है, third will be आपका unsecured creditors like आपका perpetual bonds or we can say subordinated bonds and all. Then last आपका shareholders of that company. Even in shareholders also we have preference and equity. In preference, shareholders get preference over the equity. So this is the sequence. So as per these four options, workers salary for up to 24 months, they'll get utmost priority, right? So as per IBC, workers due for 24 months are given priority over secured creditors in case of liquidation. This provide ensure that employee receive their wages before claimants providing financial security for workers affected by the company insolvencies. Understood? Very important one. Please do remember this one also. Okay, let's have a look. So it will strengthen hand of lead lenders to recover outstanding debt by setting out deadlines of 180 days. Please do remember this. 180 days plus 90 days after moratorium period. Overall, it is 330 days. After that one also, 180 days plus 90 days plus some documentation and all, that is aapka in total it max to max it can be 330 days, right? So the benefits of IBC basically, okay, so it will strengthen hand up of lenders to recover outstanding debt by setting a deadline of 180 days for companies to pay or face liquidation. Again, to create insolvency professionals who will specialize in such cases, assist creditors, manage the liquidation process. Okay, these professionals will in turn be certified by the newly created insolvency professional agency. It will also create a good database and form this disseminations of information is possible related to the debtors team. The entire operation of insolvency and bankruptcy through these various newly created agencies will be overseen by the regulators, Insolvency and Bankruptcy Board of India. Workers' salary for up to 24 months will be get first priority in case of liquidation of assets of a company ahead of secured creditors. Money due to employee from PPE, PPF, Public Provident Funds, gratuity funds will not be included in the estate of a bankrupt company or individual. As per the World Bank report, India ranked in resolving insolvency went from 136 in 2017 to आपका 52 in 2020. So you can see a huge transition between within these 3 years आपका. ठीक है, चलो आगे बढ़ते हैं guys. Next one. Which of the following regulatory mechanism ensure fair competition in India in India's banking and financial services? So it is CCI, not only in banking, everywhere. Okay. So CCI आपका, ठीक है, financial benchmark priority, no. So Competition Commission of India oversight on mergers and acquisition in financial sector. So option C without any doubt. ठीक है, CCI Competition Commission of India ensure that financial sector mergers do not create monopolies or anti-competitive practices, maintaining a fair competition. Next one, what role does IBBI team, so Insolvency and Bankruptcy Board of India, play in India's financial regulatory framework to oversee the restructuring and resolution of distressed companies under the IBC? Yes, to regulate merger and acquisition, to set monetary policy, to no. Option A only will be right answer for this particular one. Okay. So IBBI is responsible for implementing IBC, which provide a structured mechanism for resolving stress companies and financial institutions. Okay. Next one. So next question is about NARCL. Again, it is a bed banks. So which of the following statement correctly describe the purpose and function of National Asset Reconstruction Company Limited? ठीक है? So it work as a bed bank. जैसे ARCs आपके काम करते हैं, Asset Reconstruction Companies. ठीक है? So basically the primary objective of this particular institution was to help public sector banks. Basically what we generally do, public sector banks, they generally transfer their NPAs to NARCL, and NARCL pay upfront 15% of the outstanding balance. Remaining 85 they generally kept as a security. If it is got recovered, then they'll pay it. Otherwise, आपका written off में जाएगा. Nowadays, private bank are also eligible, or they are also taking advantages of this particular. But primary जो objective था, that was for public sector bank. ठीक है? NARCL was created to replace existing. No, we did not replace. It did not replace the ARCs. NARCL acquire bad loans from bank at market value and sell them to private investors. No, they are. This is also wrong. NARCL was established to purchase stress asset from bank at a net book value, paying 15% upfront in cash, issuing security receipt for the remaining 85%. 100% true. So NARCL was set up as a bad bank to acquire stress asset of public sector banks. It purchased bad loan at net book value, paying upfront 15% in cash and issuing security receipt for the remaining 85%. This structure helped clean up public sector balance sheet, public sector banks balance sheet, allowing them to focus on core banking activities. The idea of NARCL will acquire to stress asset in this. So bank will transfer identified bad loans to NARCL at a net book value, book value less provisions. NARCL will pay, how we calculate this net book value, it is book value minus provisions. NARCL will pay 15% upfront and remaining they'll issue this. NARCL has been set up as a bed bank around 2 lakh crore rupees of stress asset of public sector bank. Private sector bank can also transfer their NPAs to NARCL. The NARCL will then focus on resolving these bad loans or bad assets through various means, restructuring, selling to ARCs, invoking a change in ownership under the IBC, etc. Right. Next one. Which of the following correctly describe the impact of PCA, prompt corrective action framework, imposed by RBI on weak bank? Okay, so there are three major consideration under PCA. One is profitability, another one is आपका net non-performing asset, and the third one is CR. ठीक है, CRAR. ठीक है. So if and like we have minimum standard for these one. If any bank they won't be able to maintain these particular things, ठीक है, अगर वो उस लेवल से नीचे आते हैं, so RBI impose PCA on those particular banks. Right now we do not have any bank in this particular category, but it was also helpful कि हाँ, we can identify कि these are the banks who are kind of poor performer in the market. So RBI can have some sort of focus by imposing some sort of restrictions on those particular banks. जैसे cost cutting आपका, they cannot open new branches, or like we have three different categories under the PCA itself. Okay? So PCA allow RBI to merge weak bank. No. PCA restrict lending, dividend distribution and branch expansion for bank with weak financial health. 100% true. Option B. Okay? Under PCA, bank that breach regulatory threshold of capital adequacy, that is CRAR of 9%. Asset quality, your net non-performing asset is the more than 2.5% or somewhere this thing, and profitability. Okay? So face restrictions on lending, landings or branch expansion or issuance of dividends. Okay? The objective to prevent further deterioration and restore financial stability without resorting to immediate nationalization or halting operation entirely. Okay? So this is the one. IBC 16, which of the following is the maximum time limit allowed for the resolution of a corporate insolvency case? Maximum 330 days. Okay? Yes. So 330 days including extension and legal procedures. Okay? So usually it is 180 days. Extension is आपका 90 days and आपका remaining, that is legal proceedings. ठीक है? So आपका 180 प्लस आपका 90, दिस इज द वन. ठीक है, तो कितना हो गया आपका आपका 180 प्लस 90 इज आपका 270. 270 के बाद वी कैन हैव अनदर 90 डेज फॉर द अनदर 60 डेज फॉर द आपका लीगल प्रोसीडिंग्स इन ऑल, बट इट कैन नॉट गो बियॉन्ड दैट पर्टिकुलर वन. ठीक है, सो प्लस 60 फॉर आपका लीगल प्रोसीडिंग्स. ठीक है, सो टोटल आपका 180, आपका 170 and आपका 60, 330. ठीक है, so that's why option D will be right answer for this one, right? So as per IBC 16, maximum time limit for resolution of corporate insolvency is 330 days, including initial 180 days plus 90 days extension and legal proceeding maximum 60 days. ठीक है, this ensure a time-bound resolution of bad loans and prevent indefinite delays in debt recovery also. ठीक है, जो इसका prime objective था. ठीक है, which of the following best describe the PCA framework imposed by RBI? ठीक है, a legal process to shut down NPA, no. A regulatory mechanism that impose restrictions on bank based on financial health indicators, 100% true. ठीक है, आगे बढ़ते हैं. Okay, this is it. So this is all about your NPA and provisioning, or the updates or the RBI initiatives or the government initiatives towards this particular one. I hope you enjoy the session. Okay. So now only 3 units are remaining, and I'll try to deliver those 3 units as soon as possible. Actually, nowadays like GIB exams, I have more focus toward the JIB examination, and I have provided enough content. I hope you guys are watching these particular one on regular basis. तो एक बार थोड़ा सा आप लोग वहां तक पहुंचेंगे for sure. I'll be like within this week itself I'll be delivering all the subject. Then I'll be starting with the ABM things. ठीक है, तो ABM के लिए भी बहुत solid content आपका prepare हो रहा है, and you'll I can make sure कि you will enjoy that particular content, and that is definitely going to help you in your upcoming examination also. ABFM and BRBL is already done by Disa ma'am, so there are some playlists. Please do watch those particular one, and if you need any other help, so just feel free to ask, right? So this is my Telegram group. You can connect me over there. All right. So this is it from my side, guys. Thank you for joining this session. Thank you for watching this session. Bye. Take care all, and all the very best for your preparation. Thank you.